All right, I think we're going to begin. Good morning, everyone. Welcome to the Legislating with the Gavel panel at VICA's 26th Annual Business Forecast Conference. I'm David Goldberg, partner with Armbruster Goldsmith & Delvac, a land-use boutique firm here in Los Angeles, and I'll be moderating the panel this morning. At your seat, there is an exit survey for this panel, and I encourage you to fill it out at the end of this panel session and return it to your VICA staff, intern, or a VICA ambassador at the, I guess they're at the side of the room over here. Or you can turn it into a registration booth in the foyer after the panel. We certainly need your feedback in order to prepare for next year's event. So let's get started. The court system is designed to consistently interpret the law, but California judges instead tend to create new ones. And we have a great panel lined up for you this morning. The biographies of each of the panelists are already in the journal, so I'm going to make only very brief introductions so that we have more time for their discussion and your questions. First, we have David DeGroot, Special Counsel at Shepard, Mullen, Richter, and Hampton. Ed Howard, Senior Counsel, University of San Diego School of Law, Center for Public Interest Law. And Kim Stone, President of the Civil Justice Association. I'm going to give each of the panelists a couple minutes to make an opening statement to get things started, and then we're going to ask some questions, and then we'll have time for each of you to ask questions of the panelists as well. So Kim, why don't we get started with you with introductions?
Good morning, everybody. Glad to see you here. My name is Kim Stone. I run an organization called the Civil Justice Association of California. We fight against excessive lawsuits. Primarily, we lobby in Sacramento to try to keep California's laws from getting worse. We also file amicus briefs and sometimes promote laws to make them sort of more common sense, more fair. And we support politicians of both parties who we believe are supportive of common sense and fairness and reforms. And before we get started with our questions, although I do believe that lawsuit abuse is a very serious problem facing California, I do like to look at sometimes the lighter side of things. And so even though I'm going to have a couple examples of recent ridiculous lawsuits that have nothing to do with the California Supreme Court, and so I have to say that in my introduction because there's no way that I can weave them into my answers to the questions. One of my favorite recent lawsuits is against Nutella for not being really being part of a healthy breakfast. There's also a lawsuit, class action lawsuit against Netflix because the number of movies received was not really unlimited. There was a lawsuit by a guy who sued Anheuser-Busch because in the Anheuser-Busch commercials, the men were able to get attractive women to hang out with them after buying Anheuser-Busch beer. He bought Anheuser-Busch beer, and that was not able to happen for him. There was a man who sued McDonald's in Pacoima for emotional distress to the tune of $1.5 million because he did not have enough napkins with his burger and was unable to go to work after that. There was a lawsuit by a tourist against Universal Studios after Universal Studios employee in a costume and chainsaw came out, jumped out, and frightened the tourist. The tourist was in a haunted house on a Halloween spooktacular event, and that was the reason for that. And then the last one happened just last week, and it's short, and forgive me, but I'm just going to have to read from it because I don't want to get anything wrong. It's a woman who sued Disney, a company that you all are, I'm sure, familiar with that, claiming that the movie Frozen was based on her life. A woman has filed a $250 million lawsuit against Disney, and she was able to find a lawyer in California to represent her, and file this, presumably with a straight face, claiming that the mega hit Frozen is her life story. Isabella Tanakumi says that the animated film took elements from her 2010 autobiography, Living My Truth. Court documents obtained by E! News, and this is not from The Onion, this is from CNN, obtained by E! News includes a list of motifs Tanakumi claims were taken from her life, like 2 sisters, open doors or gates, and a moon setting. In addition to damages, she wants Disney to cease and desist from any and all sales, distribution, and marketing of Frozen in any media format. And this is the best part. The Disney spokeswoman responded to her claim, saying, "This is beyond ridiculous. She needs to let it go." No, that's true. Although some of the Netflix ones settled, and so did the Nutella one, and I don't know about the Universal Studios one. I'm done.
Great, thank you, Kim. Ed?
Hi, good morning. I do know most of the words to the song Let It Go because I have an 11-year-old daughter. If you don't like my answers, I will sing it. So make sure and at least pretend to like my answers. So I'm senior counsel for the Center for Public Interest Law at the University of San Diego School of Law. For over 30 years, CPIL has been the only organization anywhere in the country that has as its core mission overseeing and monitoring the regulatory boards and regulatory aspects of California's government, everything from the state bar to the medical board to the contractor state licensing board, but also takes a broader view on ensuring a balanced and fair access to justice. So on the one hand, we routinely take positions on legislation and bills that ensure that people have access to the courts, but the founder of the center, Bob Felmuth, was one of the first to sound the alarm about potential lawsuit abuses of the unfair competition law. So we take very seriously anecdotes like that. I will point out briefly, though, that as troubling as those anecdotes are, and they are troubling, with freedom comes abuse. And as awful as those anecdotes are, they frequently pale in comparison to the consequences of intentional, willful, and schemed-out and planned business fraud, practiced on a widespread scale that have disastrous and calamitous impacts for our economy and for everybody. Enron, Tyco, the mortgage crisis, these are willful frauds. And frequently when there are efforts to try and respond to those frauds by way of regulation or legislation, there is an argument made, and a powerful one, and often a prevailing one, that says don't make legislation because of a few abuses when the otherwise marketplace is potentially working. And on that score, I want to talk very briefly about the notion of legislating from the bench or judicial activism, because I think we should try and define that a little bit up front before the questions. I think there's a lot of different definitions of them, but I think at its core, when we talk about those phrases, what we mean is either one of two things. We mean the judiciary, the unelected or barely elected judiciary, second-guessing or overriding the policy judgments of the coordinate branches, whether it's overruling a law or a regulation, or finding some pretext or excuse to do so. And I think the second thing that we mean, which is related to it, is the court departing from the text of a law, legislative history, obvious legislative intent, or longstanding precedent. And the idea behind the whole slogan of judicial activism or legislating from the bench is that judges are doing these things to achieve some sort of essentially political or legislative aim as a way of usurping the prerogatives of the other branches of government. But I do want to point out, consistent with what I pointed out about the abuses of the lawsuits, that by these measures, the legislating from the bench that we have seen in recent years has not come from the left, but has come from the right, without corresponding criticism from the people who decry judicial activism from the right. There was a study done by the law school at Yale University which looked at the inclination of the U.S. Supreme Court justices to strike down federal legislation, the single most dramatic thing that a court can do to interfere in a political process. The justices that were by far the most likely to be inclined to strike down federal legislation were in order: Justice Thomas, Justice Kennedy, and Justice Scalia. And the ones that were the least likely to vote to strike down federal legislation were Justices Ginsburg and Breyer. Likewise, if you take a look at some of the more dramatic judicial interferences from the Supreme Court that would be clarified, that would be, I think, called activist if they were done by leftist judges, take a look at some of the cases of note. Bush v. Gore was a case that determined the election of a president where the Supreme Court stopped the counting of ballots in a state, Citizens United, a 5-4 decision, overturned statutes that had existed from 1906 onward, overturned precedent that had been decided in either 1990 and 2003 beforehand, and allowed the untrammeled ability of corporations and unions to be able to spend as much as they want. Never mind that there is no mention in the text of the Constitution of corporations having the same rights as regular natural people, or unions for that matter. And there's no evidence that the framers even thought about that when writing the First Amendment. The point is not to defend or decry any one of these decisions or their merits. The point, or my point for the introduction, is to reveal that when you're talking about judicial activism, it is too often a purely political slogan that is designed to cast aspersions, designed by the right to cast aspersions of judicial decisions on the left that they just oppose. And the problem I have with it isn't that they're opposing the decisions. It's that when you use these words, it's meant to delegitimize your opposition. If you're legislating from the bench, by definition, you are doing something which is illegitimate. You are stepping out of your role. And the problem I have with that is that if you talk to people who work in Washington, D.C., and to a lesser extent Sacramento, where Kim and I can get together and do deals, in so many places, by delegitimizing your opposition, you make it impossible to sit down and actually have a conversation with them and do business with them, because to do so is tantamount to treason. So the problem I have with the phrase is not that it doesn't happen. It does. There's a reason why when I file a public interest lawsuit, I look to try and find a judge who's a Democratic appointee. And when Kim tries to file one, she looks for an appointee maybe from the other party. There's a reason for that. Judgment requires vision and values. But that phrase, I just want to unpack it a little bit. So as we talk about legislating from the bench, we talk about it equally on both sides, because both sides either do it or don't. And there's some examples of that in California. Anyway, thank you.
You want to?
No, go for it. Go for it.
So I'll interrupt David to introduce myself. I'm David DeGroot. I'm a rare person in that I'm a conservative from San Francisco. I'm the head of the local chapter up there of the Federalist Society, as well as being an attorney at the Shepard Mullen law firm, which some of you may be familiar with. And I practice in litigation area, and so I both cogitate in my own life about these more cosmic questions, as well as try to take discrete clients through the system. Let me begin by just, because Ed would be disappointed if I didn't give him a little bit of pushback, and I think that Ed is correct in that the term judicial activism has probably gone some way to outliving its usefulness. I would disagree with his criticism of the use of the term by the right, in the sense that we lived in a world 30 years ago where the courts were just kind of making it up as they went along. And I think that in general, and this would be a topic for an all-day conference, the right at least attempts to stay within the boundaries of some kind of text, some kind of history. I think it's important to just mention that Citizens United is a very controversial decision, and it comes up, and the thing that's never mentioned in Citizens United is the First Amendment, at least when it's being criticized. And it's important to look at the details of that decision, because famously at the oral argument of the decision, the Chief Justice asked the Solicitor General, gave him a hypothetical and said, let's say that we have a book and a nonprofit corporation wants to publish a book, and it publishes this book that it just talks about an issue or a policy, and on the last page of the book it says, we don't think Joe Smith is a good candidate for becoming mayor of Calabasas, to bring David Shapiro's office into things. Can that be regulated under the statute? And the Assistant Solicitor General said, well, yes, that's advocacy of a particular position, and the statute says that, within 30 days of the election you can't do that. So the FEC can like take that book off the market or fine the publisher of that book for putting it out there within 30 days of the election. Unusually, the court asked for another round of argument, and Solicitor General Kagan showed up for her first argument before the Supreme Court and backed off of that position, but then was asked, well, what if a book was brought to the fore by a nonprofit corporation or a for-profit corporation? Doesn't matter. Most publishers in this country are for-profit, like the New York Times is. And what if they had a book that talked about things and also talked about, like, hey, we don't think that Joe Smith is a good candidate, and they're putting that out within 30 days of an election. Do you think that's possible under the First Amendment? She said, well, you know, we think the FEC could have a rulemaking and kind of, you know, figure out where the line is between advocacy and First Amendment. Now, I don't think it's a judicial innovation to say there is no line between advocacy and the First Amendment. That's what the First Amendment is. And so if in 2010 the federal government decides that we're going to abrogate the First Amendment, it's the court's job. It's their job to say the First Amendment trumps your scheme. So that being said, I'm actually a much more glad-hearted person than I just presented, and I'd like to bring us back to the California Supreme Court for a moment, and you folks are probably wondering how the court is going to be affecting your businesses and how you can predict what's going to be happening with the court in the near and medium-term future. So the court is at the beginning of a period of great change. That change is the result of the politics of this state changing. For the most part, the court has been almost completely staffed by Republican appointees, and we're going to be entering a stage at some point in the fairly near future that it's going to have a majority of Democratic appointees. And that is going to, it is unknown what that change is going to mean at this point. In the current day, the court will probably go along with its current way of doing business, which is it's a very collegial court. It is not a particularly ambitious court in the sense that it's not trying to revolutionize jurisprudence. It does come out with decisions from time to time that are head scratchers, but for the most part, their decisions are explicable and not necessarily very surprising. There are about to be two new justices. One is Justice Cuellar, who I don't know how this works, but he'll be on the ballot for retention, even though he is yet to take office. But he'll be replacing Justice Baxter, who's probably the most conservative member of the court. And then Justice Kennard has also announced her retirement, and her nominee has not been named by the governor yet. Where you will really see some change is when Justice Chin or Corrigan, who are both fairly conservative members of the court, leave. At that point, it is unknown. The court could continue on its path, and the ideological change that would take place at that point may have less of an impact than I would expect. I think that it's quite possible that we could return to a situation where, at least in some circumstances, this could be back to the days of the Rose Bird Court, where the court would have emanating from it decisions that just came out of nowhere and left people scratching their heads and wondering how, if you're a business, how you're going to conduct your day-to-day business based on complete 180s of the court. That also being said, the court is a relatively the court exists in an environment, and that environment is mostly controlled by the legislature. So part of the part of the judicial activism in this state is, I think it's fair to say, not really the fault of the court. You have decisions that look like judicial activism because statutes are so vague that it's left to the court to not really just work out little petty details, but to work out major issues that are major issues. And, you know, if you've spent time with members of the court and if you spend time with members of the legislature, you might think that it would be better to have the court decide some of these things than the legislature. But that sort of, you know, the idea of legitimacy does, I think we all agree that to have a functioning democracy, we the people have to decide things. And as a conservative, it's not a happy circumstance for me to have our legislature deciding lots of things, but that's our system, and at least when the legislature's up there, we might have a possibility of changing it. Anyway, I've been talking for a while, so David, why don't you
No, that's great.
bring
I
us
mean,
back to...
thank you, David, Ed, and Kim. I mean, I've been to a lot of these business forecast conferences. I think this was far and away the most interesting and inspiring opening statements I've ever. I feel a call to action of some sort. Your prescient skills, David, also precede you because you anticipated the first question, which was for you, about what we can expect from the current court by way of judicial activism. So we'll come back to you in a minute.
All right.
We'll move on to Ed. Are there any overarching themes or issues we're seeing right now with the California or Supreme Court as it relates to business law that our audience would be interested in knowing about?
Well, I think yes and no. I mean, picking up on David's point, I think that, you know, the court doesn't reach out and take cases. The cases come to the court, and the cases come to the court by dint of statutes that are enacted by the legislature. So to attribute themes or patterns to the court itself as opposed to the sort of the broader body politic, I think is risky. I do think that we have seen a very significant number of decisions over the last few years from the California Supreme Court in the area of wage and hour class actions and or litigation. Wage and hour lawsuits really took off. I would say probably, you know, about 10 years ago is when we started seeing a whole lot of them. And the court very recently has issued some important decisions in favor of business, interpreting current law. The court in just the last few years has held that franchisors, Domino's Pizza, for example, is not responsible for sexual harassment claims pressed against a franchisee, notwithstanding some contrary National Labor Relations Board interpretations. The winning party in a lawsuit for failing to provide meals and rest breaks is not entitled to their attorney's fees under the Labor Code. It was a very significant decision which most commentators think is going to restrain the number of those kinds of lawsuits being brought. The California Supreme Court reversed itself after the Concepcion case, the United States Supreme Court case in Concepcion, which said that waivers of class action liability in contracts of adhesion, like when you click, I agree to this, which of course you don't all read, you're probably also agreeing to waive your ability to provide a class action. The U.S. Supreme Court held that the Federal Arbitration Act preempted state laws that sought to recognize the lack of consent, the true lack of consent of those sorts of arrangements. California had a bunch of them and a whole body of case law. That's all gone now, so class action waivers are valid in California, according to the California Supreme Court. In another victory for employers, the California Supreme Court ruled that when an employee refuses a meal and rest break, the employer is not liable for that. So I think that the court, we were talking about this a little bit before. I mean, you know, litigation tends to move like water, just as business does. If there's an opportunity, we were talking about Uber, right? I mean, there was sort of a blank space in the business topography. Business rushed in and filled it, and now legislators and regulators are working backward to catch up. The same thing happens with the courts. Plaintiffs' lawyers are venture capitalists, and the same rules apply. It's exactly the same economics. They have a certain number of cases. They're investing their money in this particular case, this particular case, and this particular case, and they want a rate of return. And the riskier the case, the higher rate of return they want, just like you want for your stock or your mutual fund. So as the opportunities present themselves, the trial bar is no different than other businesses. They pursue the opportunities that are available, and the courts react to innovation in the trial lawyer marketplace, just as the legislature and the courts react to innovations in the regular standard brand business marketplace. So the themes, I think if you look to what new laws there are, privacy, wage and hour will continue to be an issue, but by and large, you're going to see far fewer big class action cases because of things like Concepcion, and probably more attorney general cases brought by public prosecutors. But by and large, I don't really see a pattern per se as much as an effort to kind of catch up with innovations in the private sector, both trial bar and business.
Well, maybe we'll take it in a slightly different direction then, rather than talk about themes and issues. To the extent that the California court does act in an activist way, recognizing that's a charged term, and with all the stipulations from your introduction, Kim, I mean, to what extent has judicial activism in the state provided greater certainty for California businesses, or is it increased uncertainty, or is it a mixed bag?
I think it's a mixed bag. I want to provide a little bit of a different perspective on two of the cases that Ed just mentioned. One of them, when an employee refuses to take a meal break, that was or chooses not to take a meal or rest break, that was an open area of law for about 7 years in California. And we had a labor code section that said employers must provide to their employees after a certain number of hours a 15-minute break, and after another number of hours a lunch break. And what was happening was that there were class action lawsuits by groups of employees against the company because some people didn't take their breaks, and they weren't being adequately, alleged they weren't being paid for the work they were doing during their break time. And what would happen is, like, an engineer or somebody would have been fired or be left, and then they would file a class action lawsuit because they were mad at the company. But the class would be on behalf of all the people who were still working at the company. The company would settle for millions of dollars and huge attorney's fees. And then, in order to protect themselves from a subsequent lawsuit, they had to require that everybody take their 15-minute breaks and their 30-minute lunches, and in fact discipline people for not doing so, which was a bit of a draconian step. And our organization and others supported legislation that would have allowed employers some flexibility in that and some relief from the lawsuits, but the legislature never approved those bills. They always died in a labor committee. And there was a case that went up to the California Supreme Court. Brinker was a restaurant case about that. And the question was, does provide a meal and a rest period mean make that meal and rest period available so you can choose whether you want to take it or not? Or does provide mean ensure that that break is taken and punish you or penalize you if you don't take it so that you can't later sue me? And the California Supreme Court, in my opinion, made the right decision and said provide means make it available, and you can choose whether you want to take it or not. And one of the new justices, Justice Liu, who was a Brown appointee, in the oral arguments was like, well, if they're free to take it or not, shouldn't they get to choose if they want to do their work in that time? And is there some amount of human dignity here where people can choose what they want to do, and if they work late, and are all employers evil sort of, cracking the whip, trying to get people to work every second of every day? And in that case, the Supreme Court provided much greater certainty to California employers by saying, and really shut off a huge fountain of really kind of abusive and extortionate lawsuits against businesses. The California Supreme Court also provided some greater certainty to retail businesses in a case that I like to call shopping is not my cardio, where a guy sued Target after he had a heart attack. I love Target, and I get very excited at some of their housewares and melamine plates and cute little things, but happily I've never had such an extreme reaction, and this poor man suffered a heart attack in Target and sued Target for not having an automatic external defibrillator on site and trained staff ready to zap him back to life, as if we expect that from all of our stores. But a lower court agreed with him, and the case was allowed to proceed and went all the way up to the California Supreme Court, where the California Supreme Court, again, made what I think was the right call. Like, no, Target and other retail establishments do not have to provide automatic external defibrillators and trained staff on hand should you have the misfortune to have that happen to you while shopping. There's one other area, though, where I think the California Supreme Court has not provided sufficient guidance to businesses, and that's regarding independent contractors and whether you, as a business owner, can or should ever label somebody an independent contractor. And although I am a lawyer, I no longer practice law, but I would strongly advise you, if you use independent contractors, to make sure you're getting very strong legal advice on that, because it is an area where people are being sued left, right, and center, and it's very unclear. We had one case that was pretty interesting, where it was a trucking case, and I want to read part of it, that said people aren't independent contractors just because the trucking company, says they are. In that case, the trucking company owned the trucks, basically hired and fired the drivers, told them where to go, when to do it, and stuff like that. And so just because the trucking company called them independent contractors, that wasn't an independent contractor. But there's another case that really still hasn't been all the way finished regarding newspaper delivery people. Like, when I was a kid, it was kids that delivered newspapers, but that's not the case anymore. Kids really can't work. And people who deliver newspapers, it's their regular job, and they do it in cars, and it's just one of the things that have changed. And the question there is, are newspaper carriers independent contractors, or do they work for the newspaper? It was a lawsuit against the Antelope Valley newspapers. And what happened there was it went to the Supreme Court. The lower court said they were independent contractors. The California Supreme Court said, well, we should resolve that. The lower court should resolve that question using a common law question of whether the newspaper carriers are employees or independent contractors. And the proper question there is, does the newspaper have the right to tell the newspaper carriers what to do? And that's not how the lower court analyzed it. And so we're going to make the lower court go back and look at it again. And it seemed to me, from reading it, that the Supreme Court wants the lower court to say they're employees, not independent contractors. And it doesn't matter, and the Supreme Court went out of their way to say it doesn't matter if they actually exercise control, telling the people how to do their jobs or not. But if they could have, if they had the right to do so, then those people need to be considered employees. And if that's the case, then that really, at least under that particular test, eviscerates the idea of them being an independent contractor. There's also like 2 other possible tests that you can use to determine whether somebody's an independent contractor or an employee. And it's very difficult as employers to know which tests they're going to use on you. And one of the tests has, like, I don't know how many, 17 different factors, but you don't know how you weigh them. And even though you get 16 in your way, if the one goes the other way, if it's strong enough, then it can outcome. And so in terms of one of the purposes of the law being to provide you as businesses with predictability and certainty and a roadmap on how to behave, that's an area where both the legislature and the courts are falling short and not giving businesses sufficient guidance.
Great, thanks, Kim. Well, why don't we open it up to questions from the audience, if any of you have questions? Yes.
So the question is, why are those coming up? Well, what usually happens in these lawsuits, there's sometimes businesses behave badly and treat their employees in a wrong way, and an employee goes to a lawyer and complains about that and brings a lawsuit. Sometimes some plaintiffs' lawyers can find look for reasons to sue, like they'll have class action lawsuits against a company and then with their named plaintiff, and then trade them out later on, so they can just sort of find out, start a lawsuit and then digging for problems later on. The independent contractor issue, I think, is tough because some folks like being independent contractors and some folks don't. There was a really interesting banking case where I can't remember what their title was, but they were basically, under a different rule, there's an exception to the independent contractor rule that if you are in outside sales, then you're not an independent contractor, because people who are in outside sales like go out and about and find new business, and so they aren't an employee, they're an independent contractor because they're out and about. Oh no, I'm sorry, that was regarding exempt or non-exempt. Forgive me, that's a wrong example. But there's a number of reasons, some of which are bad acting, some of which are trial lawyers trolling, and the other one is, I think, what Ed said, which is the sort of going into an opportunity. I mean, this area of law is tremendously unclear. I mean, so if I want to make some money on a lawsuit, like, it's really, really hard to know if you're really an independent contractor or an employee. And if I sue you, I can probably get a settlement out of it, and take my 30% and be on my way. And that's where you all as business owners really need to be careful.
Yeah, I lost when I had a public interest law firm here in Los Angeles. I've lost 2 cases where I'm lead counsel in 20 years, mostly out of dumb luck. The first is when I sued the Chief Justice, the Judicial Council, and the AOC. Fancy that I lost. It's on behalf of foster kids. But the other one was I defended my own law firm against an individual temporary secretary.
So we're on the same side now. You probably got hosed.
And I got hosed. And in fact, I was angry enough that when a friend of mine, Fred Main, used to work at the chamber, I called him up and I said, why aren't you fixing this? And I lost.
It's because VICA hasn't tried yet.
Because VICA. The problem is that the law, as Kim mentioned, the reason why there's litigation here is because the law stinks. Nobody knows what it means. I lost my case at the end of the day because the woman who was a full-time stand-up comedian but needed a paying gig, I provided her a desk, a computer, asked her when to show up, and she did not give me a business card. All those indicating that she was not truly an independent contractor. It is a law that is messy. It can't get fixed in Sacramento because of the mutual assured destruction between business groups and labor. Neither can work their way over the other to clarify it. And because, as Kim mentioned, different people are of different minds about whether or not they want to be independent or not. The math works out differently, and the lifestyle works out differently for different people. So against all of that uncertainty, it is not, beyond the pale that it's going to have to be the courts that figure it out. And the courts are going to have to figure it out against the backdrop of a whole bunch of statutes that aren't particularly well written. And what they're supposed to do, faithfully, is figure out, notwithstanding how poorly written they are, what was the legislative intent. And when they're doing that, when you have statutes that are poorly worded, or statutes or constitutional provisions that are terse, that you're applying to the modern setting, it requires judgment. And judgment is infused with personal values. That's not judicial activism. That's human beings who have to make difficult judgment calls as judges when they're not given a whole lot of tools necessarily in terms of legislative intent and text and history and whatever to do so. So circling back to one thing that Kim said, though, I mean, she pointed a finger at the trial bar. It's very interesting. The trial bar, I mentioned venture capitalists before, but they're very inherently conservative in some ways for exactly that reason. So I did public interest litigation here in LA for 11, 12 years, and frequently came up with novel ideas and tried to get some of the larger plaintiffs' firms to joint venture with me. Almost never could do it if they were a question of first impression. If you look at the early cases under Title VII or Title IX or CEQA, most of the early cases where the early decisions, Friends of Mammoth or whatever, were decided were litigated by public interest law firms. Why? Well, because if you're a plaintiff's lawyer and you're a venture capitalist, the legal topography isn't certain yet. You don't know how to litigate it. You can't forecast whether you're going to win or lose, and so you would rather do the things that you know are going to make money. Maybe you would do a flyer on it, but you're going to do the things that you know are going to make money and make payroll and make my mortgage. And I'll wait around for the public interest bar to go in and take the risk consistent with what nonprofits are supposed to do. Now, of course, we have a very vigorous private bar now that the legal topography is more certain. It's easy to say, to say, well, just as it's easy for me on my side to say, it would be that to point to Enron and Tyco and all the abuses to say, look, there's something inherently wrong with the market. Well, markets, my criticism of my side of the spectrum is we don't laud the market enough. It's an amazing thing. It's an amazing thing to be able to get up one day and start a business and fulfill your dreams that way. It's creative, it's fulfilling, it's an integral part of who we are, and it ought to be honored and respected. But it didn't come from God, and there are abuses there that should be responded to, just as there are abuses of private litigation that should be responded to, but proportionally, recognizing that with freedom comes abuse of that freedom.
Great. Any other questions from the audience? Yeah, Brad.
I'm not an attorney. I never played one on TV.
That just means you had a skill. I became an attorney because nothing else that would, nothing else people would pay me for.
So you said it twice, that with freedom comes sort of this freedom to file lawsuits. But isn't there a freedom to not have to be subjected to frivolous lawsuits and crazy stuff, and the cost to defend yourself against crazy things? And not being an attorney, I don't know what the flip side is, but what does one do? Is there opportunity to file suit against somebody? I know in my world there are issues about slap lawsuits and stuff like that, but how does that work relative to a business owner who faces frivolous lawsuits?
David, you want to start with this one?
Sure. It's a huge problem, right? This state has an incredible history of having a dynamic economy, welcoming a lot of people who didn't come from here, and making them wealthy and providing the American dream. And we're at a point where that looks like it's coming to an end, or at least is at risk. And I think that part of the strength of the state is small business and medium-sized business. Is anyone here from a Fortune 500 company? Good, because no, I mean I think there's a lot of the sense of what Ed's talking about. I think is right. Nobody wants to have people out there abusing their freedom and abusing other people, but in the effort to get at that abuse, the door is opened too wide to start to regulate behavior that isn't abuse, that's legitimate. And so you have businesses not being able to figure out what they're supposed to do. Small businesses don't have compliance departments. They don't know. You can't look at the California Code of Regulations or the statutes of California and figure out what you're supposed to do. If you're a small business, you end up doing is you do what people have done from time immemorial, which is you try to take your sense of right and wrong and act according to that and hope that 98% of the time that will lead you to the right spot. And sometimes it doesn't, and sometimes you misread that or have bad intentions, but most of the time that'll work out for you. And what we're going to is a situation where your moral compass no longer gives you any kind of reasonable advice to how to conform your behavior. The statutes are so complicated that they literally cannot be complied with by people who are really trying but don't have compliance departments. And this is what opens the door. And then, if you're a small business, you're probably not worried about abusing other people so much as keeping your doors open and having a little left over for yourself at the end of the year. And you're doing more for people who have less than you do by having your doors open than by making sure they take their rest break and having a policy that forces them out to the lunchroom, when they want to try to get something done, or maybe they want to get something done because you're happy to let them go 10 minutes early so they can pick up their kid. And these are the things that kind of probably mostly get worked out in the wash, but because that's not always true, and because we've opened the court's doors so wide, we are putting at risk what we have. There's a feedback loop. It's not just this person was bad, this person pays, end of story. Everyone else out there who is now subject to that same claim, they're saying, why do I want to expand my business here? Maybe I can get on without doing this. I was at an airport a couple weeks ago where for the first time I ordered actually a very good cheesesteak at Kennedy Airport. I recommend the JetBlue terminal there. I ordered from a screen. Screen did a good job. Like, I got my order. But I used to interact with a person. Now, maybe that person didn't have the greatest job, but that's what they could do. And now we've given those folks a lot of protections. And so the guy who's like making the steak, we still need him. He has those protections, but the person who used to take my order isn't there anymore. That's a cost that we're not recognizing from this, and we need to find a balance. You may have read recently about Tesla deciding to move to Reno. Now, part of the reason that Tesla moved to Reno was that Reno and the state of Nevada wrote a gigantic check to make them come. But why can't Tesla locate in Fresno? I can tell you why, because they'd be crazy to locate in, well, maybe not Fresno, but you know, we have maybe a part of the state that we could like look down on a little bit, but isn't embarrassingly so, like Sacramento or something. But the point is that we have a big state. The coast is doing well. The coast can manage with these things. But Google doesn't employ regular people. Google doesn't employ someone who doesn't have a lot of skill. And how are we helping those people by making it impossible for businesses like yours to function? You guys can still function, but you're functioning less well, and the things that you could do, the dynamism that you could bring to the state and to bring to people who want to work and who want to contribute, instead that dynamism is getting dissipated by having to deal with headaches, lawsuits that aren't really going to, at the end of the day, help a lot of people. And I think that we don't want to have the kind of flagrant abuse that Ed's talking about. Everybody agrees with that. We're not talking about anarchy here. What we're talking about is rebalancing so that you can conduct your business and you can predict. I think Kim really hit the nail on the head talking about predictability. On Monday morning, when you walk into the office, you just want to know what you're supposed to do. And then you can get on with your business, which is what you should be spending 99% of your time doing. And if you're spending lots of time trying to figure out what you can and can't do, we're not going down the right road.
Can I add something?
Yeah, go ahead.
I think the answer to your question is attorney's fees. I think the reason that there are crappy lawsuits out there and the businesses settle them even when they're no good is because the threat of having to pay the other side's attorney's fees. And originally, the idea of paying the other side's attorney's fees is in the kind of really bad case where the defendant did something horrible and the plaintiff in suing them was not just avenging their own wrong, but also conducting a public good, you know, by spanking the big bad actor. And so therefore they deserve to have their attorneys paid for because they enforced a public right as well as the private wrong against them. And in theory, that makes sense. And so what our legislators did is they expanded the ability to get attorney's fees to any prevailing party. Prevailing means you win, even by a little tiny bit, like you get them to like admit that they forgot to dot the I in that one contract on page 47, and then you're entitled to your attorney's fees. And they can get so large and be such a hammer that then makes the businesses settle, even if the lawsuit is crappy and even if they didn't do anything wrong. And not to be preachy, but that's partially your fault by not paying attention to your legislators and not holding them accountable. And we as citizens can and should pressure our legislators to change the laws that have gone too far, that have outlived their usefulness, where the pendulum has swung too far in the opposite direction.
That's actually a really good example of proportionality, because the other reason for attorney's fees is a recognition that there are certain individuals whose damage in and of themselves is not all by themselves sufficiently large to attract the for-profit people that we rely on to enforce most of our laws, and that's what the trial lawyers are. I mean, in fact, in a weird way, if you step back for a second and consider the alternatives to tort law, to personal injury law, really, there's three alternatives. The first is just let everybody be hurt. The second is some massive form of social insurance, taxpayer paid for. And the third is the system we have, which, if you were to step back from the old veil of ignorance, you'd think would come out of the Heritage Foundation, a for-profit-based system whereby the people who cause the harm are required to pay. Personal accountability, for-profit delivery, the opposite of social insurance. That's the tort system we have. The reason why we have attorney's fees, notwithstanding that we may not always need them, but the reason we have them is because if, under our system of government, we recognize that there are certain kinds of cases for which there is an insufficient for-profit motive for the for-profit people we have relied on to enforce these laws, and so we offer it to them.
But we don't. But the problem is it's gone beyond certain kinds of cases,
and
and you get it in these crappy 80. I mean, in
Right.
most cases, you have the prospect of attorney's fees. If we were more limited or more judicious in it, or if it was a more appropriate way, I'd be all in favor of it.
So
like Enron, pay those lawyers, yay! You know what I mean? But like, the squeeze in kind of type thing. Not so much.
Right, and we can have a conversation about what those abuses. The problem, one of the things I was going to trace back to this, though, is the challenge in dealing with whether they be quote unquote frivolous lawsuits or untoward business behavior in Sacramento. I can't really speak for DC. Goes back to my original point about judicial activism and that slogan, and I will bore you with a story. When I was here in Los Angeles. For a while, I was head of a similarly named organization called CLIPPI, the Center for Law and the Public Interest. And the LA Times ran out of things to write about, and they did a profile on me one day. And every lunatic in the 818-310 and 323 and 213 area codes called me with their case, right? And one of them, this is 1994, one of them, and those little while you were out things, was a woman who claimed, quote, my identity had been stolen. And I never heard of that. That's going to be a fun one. She's going to be a loony. And as it turns out, she had had her identity stolen. Nobody had known about it. We sued the big three credit bureaus, settled out with two, got a precedent-setting, policy-changing settlement or verdict at the end, and then settlement against the third. And then I discovered in the process of doing this case that, in fact, California had an analog to the Federal Fair Credit Reporting Act, and the state law was not preempted. So I ended up writing the state's first identity theft bill. I'd never done anything, really, in Sacramento. And when I was working on it, I was sort of guided through the process by a lobbyist from Consumers Union. And I said, well, why don't we, he says, well, your bill won't go anywhere. It'll just get killed by the bankers and the retailers when it goes to the banking committee. And I said, well, why do bankers and retailers like identity theft? Costs them a bunch of money. It makes them falsely risk averse in their lending. Why don't we just sit down and talk with them? Well, they'll never, and we did it. We sat down and talked with them, and it took a long time because they had to realize that I wasn't out to destroy them, and I had to overcome the suspicion that they weren't out to steal people's identity. I don't have the kind of mustache that can do that, and we did a deal. Now, identity didn't solve identity theft, but it made it a little bit better. And, the whole thing was profiled in the Wall Street Journal. These two groups get together. The problem is that the politics of how to accomplish your end frequently gets in the way of being able to solve a problem. It's very hard for groups that not just oppose each other out there in the body politic, but disdain each other, negate each other, the legitimacy of each other, to then sit at a table and not have believed, just put their political BS aside and now try and do a deal. You can't, the nature of the politics informs the ability to solve a problem. You're not going to solve frivolous lawsuits, quote unquote, now, or make it much more difficult, because some things that are dubbed frivolous really aren't, or have something beneath them. Just as, when consumer groups go out and complain about this, X, Y, and Z, they'll try and, if you're demonizing the other side, they're going to remain demons, and you're not going to be able to solve a problem. It's going to be much, much harder to do it. Or what will happen is the abuses will have to become so profoundly awful that finally a consensus emerges that there's a problem. But the ability to solve problems when they're just problems as opposed to problems is terribly crippled by the way we do our politics.
I think we're getting close to that with the Americans with Disability Act lawsuits. We've been talking about that for 10 years, trying to get some relief for businesses who don't realize that they may be in a technical or minor violation of the ADA, which is different than an actual access barrier that actually limits, somebody's ability to access the business. But our law doesn't treat those two any differently, and you have a small number of lawyers going around suing hundreds of businesses at a time, getting super rich, making the rest of the lawyers look bad. Although we've been talking about it for a long time, I feel like that's an issue that is getting closer to hopefully getting some relief.
Well, in the last few minutes we have left, why don't we turn to a practice pointer? We've talked a lot about the complex web of law and regulation that governs business, and that small business is not in the best position to really know the rules they're supposed to be playing by. So David, let's start with you, maybe then go across the table. What's the best way for small businesses to really stay abreast of developments, the court cases that may be affecting them, and things that may be coming down the pike where maybe there is a law or regulation that is uncertain and the courts may be providing clarity? How can small businesses stay best informed?
So a couple of suggestions. One, I can put in a plug for my own firm, Shepherd Mullen, and we, probably like every firm, have a series of blogs that are organized around discrete legal areas. So you can look at our website and find our blog page and find updates on employment law. We have an art law blog, so if you have some fine paintings at home, you might be interested in that. And there's no shortage of resources that are based in that. So figure out where the legal issues in your business typically arrive, and check those every month or two just to see what's going on. The second thing is, it's always, the legal practice has kind of become so specialized that it's very hard for a lot of private practice lawyers to really stay abreast of all things. And it's worth your while to have either someone who is a specialist in the area where you have the most issues. If you have a lot of employees, it's really critical that you have someone who really knows labor law to try to guide you through it, because it's extremely risky at this point. If you have issues beyond that, find someone who has enough breadth in their practice that they keep track of major currents, and meet with that person once a quarter. Take the time and find someone who's not going to bill you for having lunch with you, or who's not going to bill you for spending
Like
half
you,
a
David?
day. I would do this, but
I only said that because I know you're in San Francisco and they're down here. I wouldn't have been that.
I'll take calls, but truly, it's finding someone who you trust, who can give you a little bit of guidance, and even if they're not expert in an area, just a little bit of judgment to sort of, oh, I know you didn't realize that you were about to walk off a cliff, but you are. So step away from that cliff. And here's how to accomplish what you want to accomplish. But have an advisor who can help you find your way, because you'll be able to avoid problems before they become liabilities. And also, I think it's a good idea for you to partner with your insurance broker. Insurance brokers can be very, very helpful and really line up your coverage so you can have some of the risks that you ultimately have to face in running a business. Some of these risks can be insured against, and you can figure out what kind of risks you want to take and what kind of risks you want to avoid. But those are some of the suggestions that I would have.
The last thing that David said, I think, is incredibly critical. I mean, we live in a complex society. If you're a small business person or mid-sized business, you're working lobbyist hours and partner hours, and you're worrying about your business. You're not worried about compliance. So the insurance is a really, really, really smart investment when it comes to money up front versus payoff. That's a really smart piece of advice. The second are organizations like this. I think that it's very important for mid-sized and small businesses to be parts of organizations like this, because they'll frequently give you some information, and also to the extent your interests are at stake, you ought to be participating. At least you'd be amazed. Everybody thinks that nobody in Sacramento wants to hear from anybody other than lobbyists. It's exactly the other way around. When I worked for a state senator and someone from the district called, the office came to a halt. And it would be, there's a real person on the phone. Who's going to talk to the real person? There's a real person on the phone. Every one of your members will see you here in the district office. If you ask, they're eager to hear what's going on with your businesses. So participating in groups like this one is the other one. I think the other one, to amplify a little bit about something that David said, I would, if your business is heavy into one area, like you have a lot of employees or you have environmental risk or something, think about going to the lawyer that David mentioned like you would going to a doctor for your annual checkup. There was a wonderful program run out of by HLSA, HIV/AIDS Legal Services Agency. It's now, I believe, at UCLA Law School. But they started for people living with HIV and AIDS something called a legal checkup. Literally, when you were diagnosed, this is just at the beginning when people were able to survive the disease. They'd go in and figure out what all of your rights were and how to work through it. I think for businesses that have some exposure, think about it like a ounce of prevention. If you have a good lawyer who's not going to charge you an arm and a leg simply for sitting down and getting some good advice about how to avoid liability, boy, that's the best, $400, $500, $600 for an hour that you're going to pay. And I know all of us here are constantly troubled by our relatives calling us not before a problem arises, but I didn't want to bother you. Well, it's a hell of a lot more bother now. But the same applies for your business. It's just a daunting task. And then recognize that you live in a world where my favorite quote about litigation from a friend of mine is a partner in a big labor side firm in D.C. The worst thing about litigation is that it's only arbitrary some of the time. And that's the same. Some of it's just bad luck. It's no different. Being hit with a lawsuit sometimes is no different than if you're the mom and pop drugstore I used to go to, having Walgreens move in across the street and a year later you're gone. Some of it's just the roulette wheel.
I'm passing around a thing so you can sign up to get our emails. That's one way you can be updated. I also commend you for being members of VICA. VICA in Sacramento is a well-respected and strong advocacy organization that represents you all on your behalf really well. And the more involved you can be with organizations like this, and I echo what Ed said about talking to your politicians. When you run into them, calling them, writing them letters, they absolutely do listen. You are voters. You are the people who get them elected. You do not have to continue electing the same ones if they are not doing a good job of representing you, and I urge you to exercise that right. There are some pending issues that are coming up. There's a case called Kilby versus CVS Pharmacy regarding whether employees have the right to sit while on the job, because some of the folks who work in front of cash registers stand, and there's a class action lawsuit about whether they have a right to sit. There is unsettled law in the ADA arena regarding if you have a website and if your website needs to be coded in a way that people who have blind readers can access it, whether that's required to be the law or not. And then there are a multitude of other issues that I won't go into now, but as things change and become, we will put them in our monthly newsletters and are happy to share them with you. And thanks for having us. This was fun.
Unfortunately, that's all the time we have for our panel. You've been a great panel. Let's have a round of applause for all of them. This is some of this discussion about who's in the best position to avoid the harm brings me back to my days at University of Chicago and the School of Law and Economics. So thank you, Ed, for that. Just a couple housekeeping announcements. Please be sure to fill out your exit surveys and provide them to VICA staff. And the next panel begins at 11 a.m. In the meantime, we encourage you to visit all of our exhibitors and make sure to return your bingo card to the VICA registration table for your chance to win a number of prizes, including tickets on Southwest or Seaport Airlines. Thank you and enjoy the rest of the day.